As we get started, I'll just remind everyone that this is intended to be a conversation. The Cleveland Metropolitan Bar Association launched the Hot Talk series back in January of 2017. And we did so as a way for our members and the public to come together to engage in civil and constructive conversation on issues that are ripped from the headlines. There's no question we've had a number of conversations, some more political than others, but today's conversation is certainly something that is evoking all kinds of reaction. The group that we've assembled in terms of our legal experts will present different perspectives, and our goal here is to not present a partisan view, either pro-Democrat or pro-Republican, pro-liberal or pro-conservative. We are simply attempting to engage in a dialogue where we consider all the various aspects to what are some of the most compelling and complex issues of today. Again, I'm Becky Ruppert McMahon, the Chief Executive of the Cleveland Metropolitan Bar Association. Without further ado, I'd like to introduce our three panelists today who will take over the conversation. As they speak for the first 20 to 30 minutes, I would welcome you to submit your questions either on Facebook as a comment, or you can use, if you're participating by Zoom today, the chat feature on Zoom. Feel free to send your questions. We will be monitoring. And if anyone is concerned about posting publicly, I would welcome you to send me an email directly to rmcmahon@clemetrobar.org. That's rmcmahon@clemetrobar.org. I'll put that on the chat as well. We would welcome your questions today. Our three panelists, by prior arrangement, have agreed that Melissa Bertke, who joins us, Melissa is a partner with BakerHostetler. Melissa is going to serve as our unofficial moderator for today, but you will definitely hear from all three. Melissa, thank you for joining us today.
Like you said, I'm a litigation partner at BakerHostetler. I've been practicing law for about 15 years. I want to start by saying that any opinions or thoughts I express today are my own and do not represent the opinions of BakerHostetler. I'd like to tell you a little bit about my practice. I'm a general litigation practice, which spans a wide variety of subject areas, but it has consistently included First Amendment matters. I've represented TV stations and newspapers in dozens of First Amendment cases. I've counseled entities on balancing First Amendment rights with maintaining public safety at public events. And I've counseled news entities providing coverage of protests. I should note that 99% of my First Amendment practice is on the defense side. So I'm almost always arguing in favor of broad rights under the First Amendment. So if I have a bias, it's probably in that direction.
Great, thank you, Melissa. And again, we're delighted that you're here. Also joining us is Eric Long. Eric is a partner with the law firm of Friedman and Nemecek. Eric, thank you for joining us.
Great to be here. Thank you, Rebecca, and thank you to the CMBA for hosting. I think this is a really timely topic. It's obviously something that's going to continue to develop both within the judicial system, I expect, at some point, and also as a matter of public discourse. So I appreciate it. As Rebecca had indicated, I'm a partner at Friedman Nemecek, which is primarily a criminal defense firm. In that practice, we regularly encounter charges against individuals where part of the defense is going to be individuals' rights to protest and to peacefully assemble and speak as protected by the First Amendment. I also have a practice that deals with representing accused students and professors, faculty members at colleges and universities across the country. In that realm, we certainly see a lot of individuals who are disciplined for some sort of post or comment or lecture, things of that nature. As it relates to public institutions, certainly falls under the First Amendment as well. So both kind of practices do focus and at times on First Amendment issues in the defense. As Melissa had said, most of our practice also is on the defense side in trying to take advantage of the protections that are afforded by the First Amendment. So I look forward to this conversation. Absolutely.
Great, thanks, Eric. Okay, and you guys have to quit calling me Rebecca. That's only when I'm in trouble. Thank you very much. All right, and so then rounding out our third member of our panel is Professor Joe Mead, who joins us. He is a professor at Cleveland Marshall and also works with the ACLU. Joe, I turn it over to you to introduce yourself.
Hi, everyone. Good afternoon or good morning, depending on where you are. Thank you so much for joining us. This is certainly an important topic, and it really hits at the heart of the events. All of this conversation really hits at the heart of who we are as a nation and what we want to be and what does the Constitution stand for. I am a faculty member at Cleveland Marshall College of Law and the Maxine Goodman Levin College of Urban Affairs. So I teach students, law students, and I write articles. I also litigate a lot. I've litigated both for the ACLU and for the Department of Justice, First Amendment cases. For the Department of Justice, I was defending the constitutionality of federal laws against a challenge. At the ACLU, I tend to work with the ACLU to bring challenges to federal laws, including challenges, for example, to the RNC protest zones. I've represented protesters in those sorts of situations. So I look forward to our conversation today.
Great, terrific. All right, at this point, I'm going to step away and I'm going to let the three of you take it over. Thank you.
All right, so I think I said I would do a very quick overview of the relevant First Amendment principles before we dig into the conversation on how it applies here. So as you probably know, the First Amendment is extraordinarily protective of speech, even hate speech, racist speech, inflammatory speech, speech that invokes violent concepts is protected under the First Amendment as a general rule. There's a narrow exception for in speech that incites imminent lawless action. So under a couple of cases that the Supreme Court decided, including Brandenburg versus Ohio, which involved a KKK rally, and the NAACP versus Claiborne Hardware, which involved a boycott of a racist whites-only business. The Supreme Court said that in order for speech that calls for violent action or lawless action to be outside the bounds of the First Amendment, the speech must explicitly or implicitly encourage the use of violence or lawless action. The speaker has to intend that the speech will result in the use of violence or lawless action, and that violence or lawless action is the likely result of that speech. The mere fact that a speaker knows that a crowd may react violently to the speech is probably not enough. And I'll give you one example from the Sixth Circuit, which is the jurisdiction, the Federal Court of Appeals that covers Ohio, and not DC incidentally, but Ohio. But it involves President Trump. Trump at a rally told the crowd that was riled up, there's a group of counter protesters, and Trump said, "Get him out of here, get him out of here, get him out of here." He said it 5 times. And then he also said at one point, "But don't hurt them." In response, the crowd, in fact, attacked the counter protesters. The Sixth Circuit said that that was protected by the First Amendment. And it was because there wasn't enough evidence that the speech itself implicitly or explicitly encouraged the use of violence or lawless action. And the court found it significant in that context that Trump said, "Don't hurt them," suggesting that that sort of implicitly limited the statement. So that's just the very rough guideposts of where we are in terms of the First Amendment. And Melissa, do you want to take it from here? You're on mute.
Thank you. Thank you, Joe. That was very helpful. So what I'm going to do is walk you through some of the events leading up to January 6th and then at January 6th to discuss, whether or not any of the conduct involved amounts to that incitement exception, which, as Joe explained, is a very, very narrow exception. It's a very high bar to meet. So first, let's talk about the events leading up to January 6th. Throughout President Trump's candidacy, he held numerous campaign rallies, which were widely attended, very popular. Amongst the supporters that attended those rallies included some right-wing extremists. Of course, it's not everybody that was at the rallies, but there was a following that grew over the course of the last 4 years. For months before Election Day, President Trump repeatedly told his supporters that Democrats had rigged the election. And this rhetoric ramped up after he lost the election. There were dozens of lawsuits that were filed contesting various aspects of the election. When those challenges proved unsuccessful, President Trump started urging Republican senators to fight for him. In the weeks leading up to the January 6th riot at the Capitol, President Trump repeatedly said he wanted his supporters to fight Congress on accepting the Electoral College results that showed Joe Biden won. Then on December 12th, there was a pro-Trump rally in Washington, D.C. That day, President Trump tweeted, "We have just begun to fight." So far, these words are, people may disagree with his views as far as whether or not additional dispute of the election remained at this point as of December 12th. But the words "we have just begun to fight," I think most people would agree are not inciting anybody to do anything. In particular, it's more, rhetoric about, his views on how the election went. A week later, Trump tweeted praise of a report by his advisor, Peter Navarro, alleging election fraud. He tweeted, "A great report by Peter, statistically impossible to have lost the 2020 election. Big protest in DC on January 6th. Be there, will be wild." And so this tweet, I believe, kicks off a series of tweets over the next several weeks where President Trump tweets teasers for the big protest in Washington, D.C. on January 6th. On December 26th, he tweets, "Never give up. See everyone in D.C. on January 6th." On the 27th, he says, "See you in Washington, D.C. on January 6th. Don't miss it. Information to follow." On January 1st, he tweets, "The big protest rally in Washington, D.C. will take place at 11 a.m. on January 6th. Location details to follow. Stop the steal." Then, of course, on January 4th, at a Georgia rally, the day before the Senate runoffs, Trump tells his supporters, "If the liberal Democrats take the Senate and the White House, and they're not taking this White House, we're going to fight like hell. I'll tell you right now," Trump said, "we're going to take it back." So stopping here at January 4th, I'm interested in hearing the perspective of Joe and Eric, whether or not we are encroaching into the territory of incitement at this point.
And I'll turn it over to Eric, but I want to highlight something that's really important. And I think all three of us agree, which is that we're talking about the First Amendment as a constitutional protection against civil or criminal liability. We are not talking about social, moral, political responsibility. So even if speech is protected by the First Amendment, there's broad consensus that it can still be held against somebody in other contexts, right? Like, the First Amendment might protect me from going to jail because I say something mean, but my wife doesn't have to put up with it, right? Like, that's an example of the sort of social responsibility. And so there are other political avenues that are relevant here. Just want to make sure that that piece doesn't get missed. But Eric, I'll turn it over to you.
Yeah, that's a great point, Joe. And I think one of the things that is interesting, as we talk about the speech associated with kind of the recent events in the Capitol and leading up to it following the election, even though some of the speech made by supporters may be protected under the First Amendment, where there is other criminal activity aside from the incitement charges, these comments absolutely not only would likely, but likely would be used to show intent. So, for example, to the extent that there are people who are organizing these events, not at Trump's level or even somebody like Rudy Giuliani, but somebody on Parler, for instance, is saying, specifically, let's take up arms and go, and then they are charged with some sort of criminal action for what took place, whether it's assault, whether it's trespass, whether it's unlawfully accessing the federal building or property. These statements can be used, and it's not going to be a bar on admissibility of these statements in a criminal case. But as we've talked about, speech that is protected under the First Amendment cannot be the basis of criminal charges. But I think it is really interesting as we get into, are there criminal charges that can stem from the speech, not only of Donald Trump, but also Rudy Giuliani, who made a comment of trial by combat, and other supporters and other organizers of these incidents at the Capitol. So looking at the criminal side of this is very interesting. We always have to keep in mind that the decision makers, as it relates to charges, have wide discretion as to how they charge. And so just because one organization, one office or individual may look at something and say, I've got these facts to charge it, doesn't mean that others would. And I think there's already been some discussion from the Department of Justice that there are not charges relative to sedition being filed, but that obviously could change with the change of the administration coming up. But as far as the charges that have been to date, we have not seen any charges that would invoke a defense of the First Amendment by the speakers. So the charges that have come from this incident are related to federal statutes such as knowingly entering or remaining in a restricted building, violent entry and disorderly conduct on Capitol grounds, assault on federal law enforcement officers, cases like that. Obviously, there is an investigation going into additional criminal conduct. There's the murder investigation to the officer who died at the hands of the rioters, as well as, again, potentially charges relating to sedition, some angle perhaps on terrorism because of the politically motivated conduct. So I think the criminal aspect is really interesting as it relates to the kind of the universe of action that took place there. As it relates to specifically Donald Trump and whether he would be charged just based on the facts that are there, and not talking about any decision of should we charge or should we not charge based on political statements or perhaps restraint in the interest of unity, whatever that may be. As I look at it, I think it'll be very difficult to charge him, and especially difficult to convict him of the incitement. And mostly, I think that's looking at the specific language, although I think the time proximity has been met, given that he initially, or that the conduct took place in the immediate aftermath, of the, hey, let's go down there right now to the Capitol, I'm coming with you, and we're going to be fighting.
So Eric, let me...
Yeah, go ahead.
I'm sorry, let me interrupt you. I do want to get through some more timeline of the details of what happened actually on January 6th, just so that everybody has the same context for the conversation. But the question that I wanted to pose to you was stopping at, and I think I know what your answer is going to be, stopping at January 4th, where all we have are encouragement to followers across the nation to converge on DC for a rally, and the rhetoric of, if the liberal Democrats take the Senate and the White House, and they're not taking this White House, we're going to fight like hell. I'll tell you right now, we're going to take it back. That alone on January 4th, what are your views on that statement? That I think what you said just towards the end is that there is not the time proximity for that statement, but there may be a time proximity value that's met later on at later statements that happen.
Right. There are some cases that have come down that talk about the proximity. So I think generally later, let's do something, or let's plan on doing something later, typically is problematic in order to prosecute those cases. I think as it relates to the comments of, let's take the White House or take the Congress, whatever it is, we're going to take it back. We're not going to let it. We're going to keep fighting. As a defense lawyer, if I were defending Donald Trump in any sort of criminal charge, I would point out the fact that there is no specific calls to violence. And much like the case that Joe had mentioned, get him out of here, do these things. I think the argument can certainly be made that he knew what was going to come and that he took steps to try to incite this. However, when we're looking at the speech itself, and we have to give deference to the words that were used, not to necessarily what's going on, all the circumstances. I think that the lack of a call for violence is going to give him considerable advantage in defending that case, even if it were to be charged.
Right.
And to answer your question in a different way, Melissa, is that everything before January 6th, so everything leading up to January 4th, the mere fact that President Trump called for people to descend on the Capitol, and even if he used specific calls for violence, it probably lacks the imminence. Brandenburg is a case where the KKK, a KKK leader said, basically, if our racist demands aren't met, we will wreak vengeance on the community. And the court said, because there wasn't an imminence there, like maybe someday, at an abstract call for violence is the way the court phrased that, that probably would not meet the imminent test for incitement.
Okay.
So what do you think?
I agree with you 100% that in fact, the stuff like stopping at January 4th is much more like the Brandenburg case than anything else, because there's not, usually I read the imminence requirement as requiring somebody to, if you said, in a bar, for instance, go punch that person over there, that is an imminent thing where within the next 5 minutes that thing could happen, versus saying we're going to take things back at some event that's going to happen down the road. I think some of the language that's been used in some of the First Amendment cases is that there's time for people to cool down after those words are said. There's time to think through actions and calm down versus being kind of in a frenzy and going to go do something. But stopping going forward now on January 6th, I think things become a little bit more of a closer call. On January 6th, of course, Congress convenes to certify Biden's win. Normally, this is just a procedural event. But this time it's contested and there's some debate and discussion on the floor. On January 6th, Trump also addresses his supporters at a Save America rally around noon. This speech happens physically between the White House and the Washington Monument, about 2 miles from the U.S. Capitol building. Meanwhile, protesters are also gathered outside the Capitol building already as Trump's speaking to additional supporters away from the Capitol building. One of the speakers at the Save America rally is Rudy Giuliani, President Trump's personal lawyer. At one point, Giuliani says, quote, "Over the next 10 days, we get to see the machines that are crooked, the ballots that are fraudulent, and if we're wrong, we will be made fools of. But if we're right, a lot of them will go to jail." At that point, Giuliani slaps the podium and says, "So let's have trial by combat." And that's, the bit of the quote that gets bandied about quite a bit. I think some news organizations have taken it out of context a bit. But that's the context in which it was stated. During that rally, Trump repeatedly said there was a need to fight and used fighting metaphors. He said, "Republicans are constantly fighting like a boxer with his hands tied behind his back. It's like a boxer, and we want to be so nice. We want to be so respectful of everybody, including bad people. We're going to have to fight much harder, and Mike Pence is going to have to come through for us. And if he doesn't, that will be a sad day for our country because you're sworn to uphold our Constitution. Now it is up to Congress to confront this egregious assault on our democracy." Trump then invited the crowd to go to the Capitol. He said, "And after this, we're going to walk down, and I'll be there with you. We're going to walk down. We're going to walk down anyone you want, but I think right here. We're going to walk down to the Capitol, and we're going to cheer on our brave senators and congressmen and women. We're probably not going to be cheering so much for some of them, because you'll never take back our country with weakness. You have to show strength, and you have to be strong." So at this point, protesters begin leaving Trump's rally in a steady stream. This is at 12:17. Before he's done speaking, and then they start heading to the Capitol. Despite using the word "we," President Trump never walks down Pennsylvania Avenue with his supporters. During his rally, Trump did use the word "peacefully" once. He said, quote, "We have come to demand that Congress do the right thing and only count the electors who have been lawfully slated. I know that everyone here will soon be marching over to the Capitol building to peacefully and patriotically make your voices heard. Today, we will see whether Republicans stand strong for integrity of our election, but whether or not they stand strong for our country, our country. Our country has been under siege for a long time, far longer than this 4-year period." And I was reading his words verbatim there. So then, meanwhile, at the Capitol at 1:15, shortly after the Trump rally, pro-Trump protesters pushed through the barrier erected at the Capitol and stormed the building. At 1:30, U.S. Capitol Police find pipe bombs at the headquarters of the RNC and the DNC. At 2:30, rioters climb the walls outside the Capitol, storm past police, and smash windows to get inside the building. They then storm the Capitol, including the Senate floor, and police order evacuation of lawmakers. At 2:38, President Trump tweets, "Please support our Capitol Police and law enforcement. They are truly on the side of our country. Stay peaceful." At 3:08 p.m., the New York Times reports that police draw guns inside the Capitol. At 3:13, Trump sends out a tweet, "I am asking for everyone at the U.S. Capitol to remain peaceful. No violence. Remember, we are the party of law and order. Respect the law and our great men and women in blue. Thank you." At 3:21, a pro-Trump protester inside the Capitol is fatally shot by Capitol Police. At 3:36, the National Guard is dispatched to quell the rioting. And about 45 minutes later, at 4:17, President Trump tweets a video telling rioters, "You have to go home now. We have to have peace. We have to have law and order." It's another 2 hours before congressional leaders announce that they will proceed with counting the votes. Overall, 4 people died at the Capitol on Tuesday. 1 was shot. 3 suffered unspecified medical emergencies. Several members of the Capitol Police have been reported injured as a result of the riot. And over this past weekend, another Capitol Police officer died. So that is the full timeline context. Given that following timeline, Joe and Eric, do either of you feel that the imminence requirement is meant for incitement concerning either Rudy Giuliani's words or President Trump's words at the rally on the morning of January 6th?
Yeah, I'll start on that question. I think that on the 6th, the words as part of the rally and an ongoing movement to go to the Capitol would fit the imminency aspect as required under Brandenburg. Again, I think there are issues with Trump's speech when we're looking at criminal liability and whether the First Amendment applies because of the lack of a direct threat of violence. And again, I can appreciate the position that is alternative to that. I can appreciate the argument that knowing the situation, using the words he used, and minimally asking for peaceful protests, and then kind of after the fact, after he whipped everyone into a frenzy, saying, "By the way, let's be peaceful," which, as we're learning with reporting that comes out every day, was basically at the begging of his staff. But I think he probably gets by on the First Amendment issues there. I think as it relates to Giuliani, even considering the context, the quote of the trial by combat is a very different meaning of fighting in a general sense. Trump has talked about fight, 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 but he's also, using that language in the context of all of the procedural ways to fight it, whether it's through the court, whether it's, through trying to get state legislatures to send different electors. There's a lot of ways that you can construe what the term fight means. I think when you're talking about trial by combat, that has a very specific connotation related to physical violence and intimidation. So I think Giuliani's words not only fit the imminency test, but also would be much more insightful than Donald Trump's. And again, that's not to say that he would be charged, but I think the argument is much stronger to bring a charge against him, him being Rudy Giuliani. Joe?
Yeah, and again, we're talking about civil criminal liability. We're not talking about impeachment. The First Amendment's not a defense against impeachment. We expect more from our political leaders than the bare floor that the First Amendment protects. But I tend to agree. When you read the speeches, there is a way to interpret the speeches that they don't exactly call for unlawful behavior. If they said, like, go down and disrupt Congress, it comes awfully close to saying that, but it doesn't quite say that. So the question will be, is there enough evidence that that was the implied message? It certainly was the message heard by some listeners, it seems. But was there enough to show that he intended that message to be heard? In that situation, you look not just to the words that were spoken, but what is the context around it? You do look to context, as I see a couple questions about that. Every message is understood in relation to its audience, but still, it's going to be a tough showing to say that his speech was not protected, President Trump's speech was not protected by the First Amendment, given the lack of an explicit invocation of a request for unlawful action.
The other thing that I would just raise as it relates to, the criminal aspect of it, there's been a few questions here. There's kind of this chicken and the egg situation going on here, right? So we've got people who have been stirred up as a result of all of the comments post-election, frankly, going back perhaps even before that, about marching on Washington, doing all these things. So if we're looking at the 6th itself, the argument can be made that the plan was already in place. So what had been going on amongst people on Parler and other social media sites, and that was the plan itself. And so even if Donald Trump had not given a speech at all, it's very possible the same conduct would have taken place. And I think that's another defense, is that this action was not caused by Donald Trump. It was caused by people who came to Washington with zip ties, with weapons, ammunition, with Molotov cocktails in a van. Those are things that were taking place and had been brought to DC prior to the specific speeches that were made on the 6th. So that's an interesting nexus as well. And just to recognize, though, obviously, if you're looking at the totality of the speeches, it could be argued that that stuff was brought in relation to the prior statements that had been made, kind of creating a conspiracy to act in this way. But I think as we're looking again just at the language itself on the 6th, and even the language leading up to it, there's kind of this gap because of the lack of imminency on the prior language, and also the lack of any sort of direction towards hostility and violence, specifically on the 6th.
Joe, one of the things, I want to jump back to something you said a little bit ago, is that there was more than one way to interpret the words of Trump's speech. In Ohio, we have what's known as the innocent construction rule. And under that rule, if words can be interpreted, if an innocent meaning can be ascribed to the words, then the First Amendment protections apply, even if the words could also mean something that is not innocent. Do you see any application of that here?
I think that it's all going to be so fact dependent. One of the issues here is that because every case is so tied to the context, to the facts, to the words, to the message, to the audience, it's hard to know how that'll come out in any particular case. I'd be curious to get your views on that. I think one thing, though, that is worth noting, the presumption is maybe not given to everybody equally. There's some forms of speech, and some speakers in particular, who are maybe more inherently viewed to be violent and not given the presumption of innocent construction. And that's something that we need to be aware of as we're discussing what the leader of the free world is saying. He's getting a presumption here that maybe isn't given to everybody. But I'd be curious to hear what you think.
Joe, I think that's right. And I think also, context, it always controls when doing a First Amendment analysis. And I think an argument could be made here that President Trump, through his experience of conducting, rallies for a long period of time, is well aware that if he orders or if he suggests to people at one of his events to do something, that there will be at least some of them that may act on his suggestion. And there's also a history and a dialogue within the in particular the far right supporters of Trump, of discussing code words and celebrating small statements by President Trump as being huge acknowledgement of their cause or their victories. We saw that during the presidential debates, when I think President Trump said something like, Proud Boys stand by, or stand, I can't remember the exact quote right now, but there was, what was reported afterwards is that the people that he was speaking to celebrated that as an acknowledgement of them and as a victory. So, with that background and with that knowledge, I think that you could make the case that President Trump could expect his words of, go down to the Capitol and be strong. Those could be expected to achieve the result that they did result in.
But I want to add that it's not a negligence standard, right? It's that President Trump has to intend that to happen as well in the words that he speaks. And so the fact that maybe even that he's aware that somebody might interpret it and act out probably isn't enough. I'd be curious if my co-panelists agree, but typically it's that the speaker's words have to be intended to and communicate that message. And sometimes that's not done explicitly. That's kind of done in a wink, wink, nod, nod, or code words. But there still has to be that kind of tangible intent shown by the speaker.
Yeah, that's a really interesting point. As it relates to the criminal side of this, juries are told, look, you'll be told what the law is, but you need to apply your reason and common sense, right? So this is not a forget everything that people know. And so I agree with you with respect to proving that the language, there was an intent behind the language. I do think there's some element as prosecutors would look at this case, and ultimately jurors and appeals courts, if it were to get to that point, of what was reasonable and what people would expect that language to mean. And the other question that was asked was, what Donald Trump may have known about some of these conversations going on relative to Parler or Twitter. The other component of this is, although we don't know what was presented or not presented, given that the FBI has come out and talked about the fact that there was this pre-planning going on, whether Donald Trump had been briefed through kind of his daily briefings of the national security apparatus as to any of this. And so obviously we don't have the answers to what he was briefed on, but I think it's reasonable for somebody to look into what he knew or didn't know and how that played out. And again, that may come up through impeachment discussions, it may come up in other areas, but from a criminal side of it, I think, again, it's always going to be the totality of the circumstances, but looking specifically at the language itself is always, I think, going to be a really critical piece, which makes it difficult as it relates to Trump.
We've received a really interesting question from the audience from Ashley Case Sletvoid. I apologize if I butchered your name. Would testimony about the president's reaction to the violence be evidence of his intent to making the statements? And so, we saw in news reports that for a long period of time, in between 1 p.m. and 3:30 p.m., President Trump's advisors were urging him to say something or do something. It wasn't until after someone was shot that the National Guard was called out. So Eric, could testimony about, if President Trump reacted was happy about the riots happening, or how he acted in those intervening hours be used to establish intent.
Yeah, I think generally speaking, you'd be looking at the intent at the time the statement was made. But I can see situations where that evidence as to what took place after the fact would be potentially admissible, and particularly in situations where, the defense was, look, he never intended it. He was upset. I did everything I could do. Making statements like that in a defense, you may end up impeaching yourself, because then you could open the door to evidence coming in of, you say on one hand that you were doing everything you can do. At the same time, here's all this evidence that you were kind of gleefully watching the events unfold and were proud of your supporters making statements in one hand that, let's stay peaceful, while the other hand saying, we still love you. I think there are certainly circumstances where that could get in. But I think that is such a fact-specific question in a ruling on the evidence that would be dependent on, how it was presented, what the defense was that may open the door to what could be otherwise inadmissible evidence, and also, most importantly, the judge presiding would have the ability to rule on those types of admissibility issues. Melissa, let me ask you a question, and in kind of the civil context. We've talked a lot about the criminal context, but to the extent that there are lawsuits brought perhaps by the family members of people injured or killed, what does civil liability look like, and how would any lawsuit, for instance, that's brought against not only the individual bad actors, but looking perhaps in a civil case to the deeper pockets and going up the chain, how would that play in?
That's an interesting question, Eric. So I have not been involved in any, wrongful death type cases or those type of civil cases. Most of the cases I handle are defamation. So the standards and the context are going to be a bit different, but I would think in a negligence action, you would have to to establish that there was a foreseeability would be the big element that would could the president foresee that his words would result in what happened, and then I think it's easy to say that you could foresee that it would result maybe in people entering the Capitol building. I think it would be a harder case to establish that everything that happened that day was entirely foreseeable. Hindsight's 20/20. I think that a lot of different things could go into the evidence of it, though. To the extent that there wasn't enough preparation by the Capitol Police to prevent the building from being breached. I think that it was certainly foreseeable that the crowd would be agitated that day. It was foreseeable that there would be large numbers of people there that day. There were permits for the protesters to be there. What we've heard from the Capitol Police is that they had planned and prepared for the First Amendment issues that would exist with a protest gathering in that area, but that they had not planned for violence. And so that makes one question whether or not they, to the extent that the president was briefed on the fact that people were planning on bringing weapons and being violent that day, and whether or not that information was conveyed to the appropriate parties prior to January 6th. I think is an interesting question. Joe, I know you've been involved in planning and protecting the First Amendment free speech zones at public events. Do you have any insight on what the difficulties lie there?
Yeah, I mean, so typically your right to protest is cabined by content neutral, time, place, reasonable time, place, manner restrictions that are kind of carefully written in a way that allows the speakers to still have their voices heard, but that puts them in areas that are safe. So for example, if like right now you wanted to have a protest that blocked traffic on a major expressway, they could say no because it's reasonable that the expressway's purpose is primarily used for transportation, and there isn't a reason why you need to block a particular expressway. And so certainly the mere fact that there was a protest held on or near the Capitol is itself one thing. Where it becomes unlawful is if you breach the security zones that were put up in place and that I think constitute in this circumstance anyway a reasonable restriction. I want to mention though, building off of Eric's question, how this liability question has played out in other cases. There's a case out of Louisiana where a Black Lives Matter protest there was an incident of violence that arose in the context or associated with a Black Lives Matter protest, and a police officer was injured. That police officer sued not the person who injured him, but the organizer of the protest, and claimed that the organizer of the protest was responsible, was civilly liable for the injury because it could have been foreseen. And the Fifth Circuit Court of Appeals agreed as a pleading matter that was a viable theory. And that went up to the Supreme Court, which in a very short opinion said, basically try again, make sure that this is actually a viable theory of tort law, and then we'll look closer to see if there are First Amendment problems with it. And I just put in I sent it just to the panelists, but I think there's a way to send it to everybody, a link to the Supreme Court decision if you're interested.
Another question that we had was talking about, specifically as it relates to the criminal aspect of this, is incitement a crime? I think incitement is a term that's used as we talk about First Amendment speech, and it's an exception to the protected speech. There are a number of crimes that would fall kind of within that realm. But there's no specific federal statute against incitement specifically. But as I had mentioned earlier, there was some talk amongst some media and people, certainly on Twitter, about sedition. There were comments made by members of the Congress about sedition, and sedition is seditious conspiracy. Is two or more people who agree to try to interfere with the central functioning of the government. And so that when we talk about what penalties could come from that, the federal sentencing is an interesting animal that we could spend a whole day or two on, if not more. But the sentencing guidelines are created by the Federal Sentencing Commission, and it's an attempt to try to regulate and normalize sentencing across the federal system. And so when we're talking about penalties, most statutes have maximum penalties. Some statutes, criminal statutes, have minimum penalties. And then every statute is assigned a category that creates a guideline range. And so instead of, some state courts, for instance, say, look, if this happens, you're looking at 5 years. There are mandatory minimums, but otherwise there's typically ranges. And it's also dependent on whether or not the person has a criminal history. So when looking specifically at the conspiracy, seditious conspiracy, it's a maximum of 20 years. But generally speaking, it's also going to be impacted about what actually took place. Are firearms involved? Were people injured? But generally speaking, the guideline calculation on sedition would be anywhere from 63 to 78 months. So that's 5 years or so. As we talk about, for instance, whether, and again, this is not the speaker in some of these instances, but the homicide that took place there, that would be potentially a life sentence. The act of simply entering the Capitol would be perhaps, depending on how it's charged, either misdemeanors, which would have a maximum penalty of 6 months in jail, or again, with with firearms and violence somewhere between 18 to 24 months. So depending on how these crimes would be charged, assuming they're charged, there's a wide range of potential penalties that might come up as it relates to the speaker themselves and whether or not their kind of incitement would be something that creates their own criminal jeopardy. You'd be looking more along the lines of the sedition, conspiracy, solicitation of an offense, which again, asking somebody else or soliciting somebody to engage in criminal conduct typically would echo what conduct took place. So again, it depends on what charge is being related to the solicitation. But even without a significant underlying offense, there could be potential prison time of 10 to 16 months just for the solicitation of some crime involved. So it's a very wide range.
Thank you, Eric. That is very helpful. We had a question from the audience. Robin Wilson asks whether there are any First Amendment implications about the fact that Facebook and Twitter after January 6th event barred Trump from using their platforms. And I'm happy to answer that question. I've written a bit on the Communications Decency Act and also on the application of the First Amendment in the context of the internet. And the important thing to remember is that the First Amendment protects citizens against government interference with the right to speak. It does not have any bearing on what private businesses decide, what speech private businesses decide to allow on their platforms. And so Trump Facebook and Twitter have full authority to allow or not allow who they wish on their platform, in my view. Joe, would you agree with that?
I think that's right. There's an interesting constitutional question whether even the government could force a Twitter or Facebook to change its standards. Throughout the history of the First Amendment over the last 100 years, the court has come down different ways, but arguably, right, the Twitter and Facebook as private entities have a First Amendment right from the government. So it's possible even that the government couldn't force them to engage in association with political actors. But I agree with your analysis there. And then I see a question. I think this is a question in response to something I said, so I'll take it. What do I mean when I say the First Amendment is kind of a floor? That's kind of an awkward way of saying it. So let me clarify. The First Amendment provides protection against civil and criminal liability. So that means I can't be held criminally liable. So in that sense, my behavior is lawful. But we all should shoot to do better than lawful, right? Especially in the context of the First Amendment. Just because they can't throw me in jail for saying something racist doesn't mean it is in any way acceptable for me to do so. So, when I say a floor, that's what I'm referring to, that what the First Amendment allows the government to regulate is not the standard that we should hold ourselves to or hold our elected officials to. Go ahead.
Oh no, I'm looking through the audience questions to pick one for us to answer. We have an audience member who asks, what about cases about shopping malls being the actual places of public relevance? Is there an analogy to social media as the current shopping malls? Again, go ahead.
Please, sorry, go ahead.
No, that's all right.
I was going to say that this is a reference to I think this is a reference to a California Supreme Court decision that interpreted basically the California version of the First Amendment to apply to privately owned public spaces, right? So as the typical idea of the First Amendment, it protects you against government regulation, and it principally protects public areas. So like if there's a protest on a traditional public forum, which would be like a big park, it's exceptionally hard for the government to do anything to regulate that. The California Supreme Court extended the analysis and said essentially that private shopping plazas have assumed the place of the public fora in a lot of ways. They're analogous, even though they're privately owned. And so we should expect that these private areas comply with some rules about access. So basically the California Supreme Court required private entities to allow different speakers access to the private property. The Supreme Court upheld that rule against a First Amendment challenge. The subsequent decisions have maybe eroded that, so it's not clear if that same decision would come down today, but that is still, as far as I believe, good law. So theoretically, that gets to the question of, could the government treat a social media platform in a similar way? I'm skeptical that that'll happen politically. I'm not sure that the courts would accept it if it did. I'm not sure that that's a great rule, but that is the precedent that's out there.
I'm going to jump in if I could and say we've got time for probably just about one more question before we wrap up here. And I've gotten a couple of emails from people who are interested in the general understanding of, do you three experts in this area, do you think that there is some sort of qualitative difference in terms of the analysis that's happening right now as a result of the January 6th protest turned riot as compared to previous events where we saw protests that led to violence and other sort of activities? What do you think? Is the media, are people reacting differently? Maybe those are two different things, the media and the general public. Are you seeing a qualitative difference to this kind of reaction that's swirling right now?
I think there are a lot of differences just kind of based on the facts here. I think starting with the speech and the end result in this particular instance, we're talking about the disruption of the electoral process, which I think is different. Let's talk about, the aftermath of George Floyd's death last summer. The riots that resulted from protests, and there is a difference there in both of these situations, were illegal conduct. So to the extent there's looting and vandalism last summer, to the extent there's destruction and criminal activity at the Capitol, there are arrests that have been made across the board on both of those things. So I don't think anyone, at least on this panel, is saying that there was no criminal activity associated with the rioting and the looting that took place in certain circumstances last summer or at other events. So I think the numbers actually bear out that there was more arrests made in relation to some of these other events, and maybe that will change. Obviously, there's an investigation going on here, but I think the underlying function of what is at issue here, we're talking about in prior instances, it's free speech criticizing police brutality, criticizing government action. This was an attempt to stop one of the truly core democratic principles that this country is founded on. I think there's a lot of differences there. So I don't know if anyone else has more to add or sees it differently, but I think it's very different.
Eric, I think that's right. And I think another, reason for the difference that you see here is that we have, the leader of our country involved in the invocation of going to the Capitol building. On one hand, we have, statements from him that show support of the individuals that are there. We love you, thank you, those types of words. And then, I think we've also seen a difference in the police response with this protest compared to other protests that we've seen over the years, not just, Black Lives Matters protests, but there's an interesting article on CNN today that lists the numbers of people that were arrested following a variety of different protests. I'm trying to pull it up here to give you some examples.
I sent it to the crowd.
You did great, thank you. Yeah, and there's, I guess we're right at 1 p.m. So we're out of time.
Although I'd love to give Joe a chance. Joe, do you want any last words to that question before we wrap up?
I mean, I think there's a difference. This was an attack on the United States Capitol. It was a well-coordinated assault on, as Congress, a branch of government, attempted to fulfill its constitutional duty. It was at least supported and praised by the President of the United States. It needs to be dealt with, I think, accordingly.
Great. Well, with that, I'm going to say thank you to all three of our panelists for joining the conversation today. Joe, Eric, and Melissa, you've given us a lot to think about, a lot to talk about. This recording is going to be available. We've had a couple of questions. We will be hosting it on Facebook Live. On Facebook. You'll see it available for replay at any point in time. And then we also maintain a YouTube channel where you can always find recordings as well. So keep the ideas coming. We put this conversation together quickly, and so let me doubly thank our panelists for answering the call to move so quickly. We are always looking for new and different topics that are coming from the headlines, just as we are also looking for new and different speakers. So if you have an idea for a future conversation that you would like to help put together, please reach out directly to any one of my staff or to me. Again, it's Becky Ruppert McMahon. You can find me on our website. And it's critically important from my personal view as well as my professional view that we keep these conversations happening with so many differences of opinions and viewpoints, and with so many who on all sides are retrenching to their own respective corners. The ability to create civil conversation with people who have reliable information has never been more important in my perspective. So our Hot Talks will be continuing, and we invite you to join us now and in the future. Thanks everyone for your time. And again, thank you to our panelists for the great conversation. Have a great afternoon, and everyone, please stay healthy out there. Keep wearing your masks.
Thank you, Becky.